This case Act 96, first of 271 of 2023.
Just refresh the mind.
प्रिलिमिनरी पॉइंट आपका ऑलरेडी रिकॉर्डेड है, अब आपको क्या बहस करना है उसको सीधे
मतलब उसी में मतलब रीजॉइंडर था इनका, मतलब मेरा रीजॉइंडर था इनके आर्गुमेंट पे कि the amendment of 2018 is not applicable. So the original specified value definition which said कि 1 crore specified value should be there. So 1 crore specified value was crossed on 30th of August 2022 when the amendment was allowed. And as per section 15(2) of the Commercial Act, it says that if the matter is pending in the specified, and if the value of the suit is more than the specified value, then it has to be transferred to the commercial court. And section 6, read with section 21, gives the exclusive jurisdiction to commercial court to adjudicate this. This is on the jurisdictional aspect.
I don't know. You see, on the day 2018 Act came into force, right? On that particular day, your valuation was less.
Was less than
Right.
1 crore.
Less than 1 crore. Subsequently, you amended the plaint, and then the valuation was enhanced, right? Enhanced to
1 crore 67 lakhs.
1 crore 67 lakhs. Do you want to say that if in the midst of a proceeding some amendment is carried out and some more prayers are inserted, then the suit will automatically get transferred to a new court?
That is what 15(2) says. Can I read 15(2)?
Yes. तब तो कोई भी सूट में कितना भी एविडेंस हो जाए फिर से सुओ मोटो चालू हो जाएगा.
सुओ मोटो तो शुरू हो गई ना, मतलब 15(3) says that it will get transferred at the same stage. It will be transferred.
Do you
at the
want to
same
say
stage.
that any pending suit, whenever the valuation is changed and changed to over 1 crore, that will get transferred?
That is what is coming from 15(2). Let me just place 15(2). All suits and applications, including applications under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of a specified value pending in any civil court, in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court. So the only requirements are that there has to be a commercial dispute, it should be more than the specified value, and it should be pending in the civil court. So if these three conditions are fulfilled,
At any stage of proceeding.
at any stage, that has been taken care of, that it will get transferred from that very stage itself. It will not be a de novo proceeding. It will get transferred from that stage. So all the three conditions I am fulfilling. The only exception has been provided in the proviso, that provided that no suit or application where the final judgment has been reserved by the court prior to constitution of the commercial division shall be transferred either under subsection 1 or subsection 2. So if prior to reserving the judgment, if the commercial court has not been constituted, then it will not be transferred. This is the only exception.
May I respond to you?
Just to please.
Section 15(5) is answer for that.
Yes, please.
Yes. In the event that such suit or application is not transferred in the manner specified in subsection 1, subsection 2 or subsection 3, the Commercial Appellate Division of High Court may, on the application of any parties to the suit, he never resorted to that, withdraw such suit or application from the court before which it is pending and transfer the same for trial or disposal to the commercial division or commercial court as the case may be, having territorial jurisdiction over such suit, and such order of transfer shall be final and binding. So it was option before them that if they say that they want to get it transferred and the petition is pending, they could have come to this Honorable High Court and have prayed for such transfer. They never it is a case of election by the parties, because remedy was given, okay, it will be transferred, an expeditious forum is created for you. If you want and it is not being done, then the remedy is come to the Honorable High Court, get it transferred, and whatever order will be, because it is not compulsory. The High Court also may look into the several aspect of the matter, can transfer it or cannot transfer it. But whatever will be done will be final. So my submission is, it is not an ousting of jurisdiction of ordinary civil court. It is just a creation of an additional expeditious forum for them. And it is the choice of the litigant which forum they want to opt.
It is not a case where a
Absolutely
court
not.
loses its jurisdiction.
Yes, absolutely not.
Because the day when it was filed,
The
it
court
was
has
within
got-
the jurisdiction.
Yes. And expeditious remedial forum is created. If they want that, no, if suit will take longer time in ordinary civil court, I can move to. Then they can exercise this election. If they have not exercised this election, then it is, they lost that opportunity.
And this option is also made.
May.
The High Court may
Yes,
on an
yes,
application.
and therefore my submission is, it is also not compulsory to the High Court. High Court can consider many things. That if yes, you are saying expeditious, but what will, there also argument is reserved. So what is the harm arguing before the court who has committed the entire trial, and what will be the benefit if the argument stage it will be given to a commercial court? No difference, no procedural requirement was left.
Okay, uh, this is first appeal number
It was 271 for 2023.
271 of 2023.
23.
The learned counsel for the appellant has submitted that at the time of filing of the suit in the year 2018,
2016.
2016, the valuation was less than the specified value which was prevalent at that point of time. In the meantime, 2018 Amendment Act came into force, and the threshold value came to
3 lakhs.
became rupees 1 crore.
But it was 1 crore since beginning. It was reduced to 3 lakhs from 1 crore.
Right. Okay. It was reduced to 3 lakhs.
Their argument is finance at 20.
Just
Amendment Act.
It was reduced to 3 lakhs. Are we 3 lakhs, sir?
Yes.
Yes, today it is 3 lakhs.
It was reduced to 3 lakhs. He submits that thereafter in the year 2022, the suit itself was amended and the valuation became more than 1 crore. And therefore, by virtue of section 15 within bracket 2, the suit ought to have been transferred to the commercial court. But the court did not take any step in spite of a petition having been filed by the appellant. The learned counsel submits that the moment the suit valuation is amended, be it at any stage, and it comes within the jurisdiction, within the pecuniary jurisdiction of a commercial court, then the suit has to be necessarily transferred. The learned counsel for the respondent has referred to section 15 within bracket 5 of the Commercial Courts Act and has submitted that by virtue of creation of commercial court, the existing court did not lose its jurisdiction completely, as the case was filed before a court which had the necessary pecuniary jurisdiction. The learned counsel submits that in case one or the other party seeks to is of the view that the matter is to be transferred to a commercial court and chooses to get it adjudicated further by a commercial court, then the party has an option under section 15 within bracket 5 before the appellate jurisdiction, before the commercial appellate division of the High Court, and thereafter it is for the High Court to take and pass an appropriate order regarding transfer. The learned counsel submits that there is no provision under Commercial Courts Act that the court before whom the case has been filed and has the necessary jurisdiction to try a suit will lose its jurisdiction completely to adjudicate.
And moreover, in this case, the case was fixed for argument. So withdrawal of case, the concept is for expeditious disposal. So there was no question of
So
this.
when was it fixed for argument?
It was fixed for argument and after amendment. They filed petition on 16/6/2023.
After increasing the valuation of the suit, it was fixed for argument or not?
Yes, because it's a ex parte proceeding. They have carried out amendment and it was fixed for argument.
There was an evidence also which was made.
Not
Yes,
by-
Just a
yes,
moment.
yes.
Not
Just
by-
a moment. It is something very serious.
not-
You file a suit for rupees 1 lakh. The party does not appear.
He appears he chose not to file.
That's
a
right.
notice.
He appears and he says, we don't bother. 1 lakh रुपए के लिए नहीं लड़ते. His counsel was appearing
His counsel was
and then the suit valuation was amended.
but
Any further amendment in the suit?
no, only one amendment.
Only the valuation.
Matlab, prayer for
Valuation.
damages were added.
Valuation
Yeah,
of certain
for damages
paragraphs
were
in
added.
the claim.
So because of those damages, prayer.
When was the proceeding set ex parte?
No, the proceedings were in their presence. Their
Where-
WS,
Is there any order setting it ex parte?
not to my knowledge.
Well, lady should may point out, they have filed petition on 16/6/2023 and on 16/6/2023, the let this case be fixed, record put up for date fixed for judgment
No, no.
as per the order sheet. 16/6/2023, amendment was carried out, it was fixed for that.
Straight away.
Yes, because the argument were,
That's an incomplete story. There is
now the order sheet says.
When was the amendment allowed? Amendment must be in the
August 20.
valuation of the suit.
August
Amendment must be in the
Friendship
valuation
of
of the deed.
petition under section 21C, Roman 18, section 6 and section 15 of Commercial Code Act 2015 and order 14 rule 2 CPC along with written arguments filed on behalf of the plaintiff. The copy served to the opposite party, let it be kept on record and put up on the date fixed for judgment. This is the order.
I don't get it. When was the amendment allowed?
30th August 2022. I have the order which permitted the amendment. 30th August 2022.
So-
And thereafter? Was the proceeding set ex parte at any stage?
Malas, to my knowledge, it was not set ex parte. If my learned friend is contending that, let my learned friend show malas.
The order sheet says that it is proceeding ex parte, the judgment itself. May I point out
They were present all the time.
page
And in fact,
88 of
They had cross-examined also after this amendment. One of my witnesses.
then cross examination, that is on record.
Cross हुआ है ना?
On
Proceeding is on-
22nd May 2023, they have cross-examined witness after the amendment.
After closure of
Almost.
evidence.
ठीक है, आपका preliminary point तो लिख लिया ना? हाँ, उसको
Just-
decide करिए.
Just
अब आप
छोटा सा मतलब only on that point of 15(5) मतलब the remedy under 15(5) मतलब would have been applicable to me once my application was rejected. My application was not adjudicated; it remained pending, and then all of a sudden the judgment came. मतलब once the judgment comes in, मतलब how would I go to the commercial appellate division and get the judgment set aside? So first appeal is the only remedy available with me. 15(5) मतलब remedy is available once my application is rejected.
No,
When it is not
that is not the
transferred.
case.
When it says when it is
It is
not
not-
transferred.
Just a moment. Then you will have then there would be an appeal against that order.
No, that
There is no provision of appeal. It is
Therefore
not an appellate remedy under 15(5).
Therefore, it goes before the commercial appellate division matters.
No,
The
it's not
forum
like
is
that.
also
It
commercial.
It is superintendence.
It is superintendence, madam, provided there is no transfer.
But there has to be a decision, right?
There has to be a decision
We
for
will,
non-transfer.
we will pass a decision on that first. But you also argue the case on
Madam,
that.
I'll argue the case on merits.
Because first appeal will be decided on every aspect of it.
Madam, indeed. Madam, I'll place the plate, madam. It starts at page 26 of the memo of appeal, or madam, let's see the lower court reports. Ma'am, please. Para 1. The plaintiff above named begs to state as follows: that the plaintiff was carrying on his business under the name and style of Kailash Corporation as its proprietor, having its office at Hotel Naresh Building, Bypass Road, UNPS Charge, District Bokaro, within the jurisdiction of this court. That the defendant is a public limited company registered under the Indian Companies Act, having its registered office at Ispat Bhavan, Lodi Road, New Delhi, and having one of its unit, Bokaro Steel Plant, within its office and administrative building, UNPS Bokaro Steel City, within the jurisdiction of this court. That the defendant company through
You can
its
read fast.
that the defendant company through its then controller of stores issued a tender notice bearing number so and so for disposal of unserviceable salvaged materials like typewriters, gunny bags, conveyor belts, AC sheets, alu cables, batteries, tires, brass, copper tools, spare parts, bronze, stainless steel, aluminium utensils, duplicating machines, and wire ropes, etc. from stores department on as is various basis. That in terms of the aforesaid tender notice, the intending purchasers were required to submit their quotation along with an earnest money deposit of 1% of the value of the material tendered for purchase, and the tender was scheduled to be open on 26th September 1979. That the plaintiff tendered his quotation at the rate of Rs 3,350 per metric ton against serial number 33 of the material list, being used an old conveyor belt of the assorted size. Quantity being 714 metric ton, along with the requisite earnest money of Rs 30,000, and the said tender was opened on 26th September 1979. That in spite of the plaintiff being the only valid tenderer, its rate was not found to be acceptable by the defendant, and therefore the defendant convened a negotiation committee meeting on 29th January 1980, wherein the plaintiff agreed to revise the rate and submitted his revised rates of Rs 6,650 per metric ton plus applicable taxes, along with an additional amount of Rs 20,000 towards differential earnest money arising out of the rate revision. That the defendant accepted this revised offer of the plaintiff, and minutes were prepared on the basis of the discussions amongst the officers of the defendant and the parties participating in a tender price negotiation meeting, including the plaintiff. That white letter number so and so dated 20th February 1980, the then controller of stores of the defendant company communicated to the plaintiff that the offer of the plaintiff for purchase of 714.8 metric ton of used and old conveyor belts of assorted sizes on as is varies basis at the rate of Rs 6,650 per metric ton plus sales tax, as applicable subject to the terms and conditions of the tender, has been accepted, and thus in this manner the contract got concluded and the title in the tendered goods stood passed from the defendant to the plaintiff. That in the aforesaid letter the defendant instructed the plaintiff to lift 50 metric ton of used and old conveyor belts in first installments after making necessary payments, and thereafter in 9 installments. May I just explain what used to happen? The Steel Authority of India Limited had entered into an agreement with us wherein they were supposed to supply us the used conveyor belts. The total quantity was approximately 715 metric ton. The practice was that steel authority will intimate us. The entire quantity was not to be delivered at once. They will give us a letter. They will explain us that this is the quantity available. You make the payment of this quantity, and then we will release this quantity. So, first they informed us that 50 metric ton is available. You make the payment, and then you can take the delivery. So, that is why para 9.
Why in para 8 you say that the contract got concluded and the title in the tender goods to
Well,
pass?
that I think its title would get transferred only on delivery. This is wrong. This is title in any.
Confused हो गया मुझे क्या
That's a wrong drafting.
चलिए आगे
That the amounts of rupees 30,000 deposited on 26/6/1979 and further rupees 20,000 deposited on 1980 by the plaintiff as earnest money against the tender were subsequently converted as security deposit against this contract. So, my 50,000 was taken as security deposit for this contract. That the plaintiff on different dates deposited a total sum of rupees 16,62,500 by way of advance payment towards first and second installment of 50 metric ton each and third and fourth installments of 75 metric ton each towards lifting of materials against money receipts granted by the defendants. The detail of advance installment payments are more fully described in Schedule A of this plain. That against the advance payment of rupees 16,52,500 for 250 metric ton materials, the defendant supplied 219 metric ton of old and used conveyor belts worth rupees 14,58,667 on various dates. Thus, a balance advance amount of rupees 2,03,000 was lying deposited with the defendant towards cost of materials against which delivery was not given. Thus, out of the total contracted quantity of 714.8 metric ton, only 219.35 metric ton has been delivered, and therefore 495.45 metric ton materials remain to be delivered by the plaintiff by the defendant to the plaintiff. The delivery of used and old conveyor belts by the defendant on different dates is more fully described in Schedule B of this plain. That the last payment was made by the plaintiff on 30th July 1980, and last delivery was made to the plaintiff on 6th of August 1980. That while the fourth installment of material delivery lifting was going on, a criminal case being Marafadi PS case number 12/8/80 was instituted on 6th of August 1980 against several persons inter alia, against some employees of the defendant, as well as some persons of the plaintiff on certain allegations on a complaint by CICF engaged by defendants, and thereafter further supplies to the plaintiff was stopped by the defendant. That another criminal case being Marafadi PS case number 15 within brackets 1180 was instituted against some officers of Bokaro Steel Plant by the police with allegations of malpractices in awarding the aforesaid contract to the plaintiff. That pending investigation of both the criminal cases referred above, the plaintiff on a number of occasions approached the defendant for supply of the balance quantity of 495.45 metric ton of used and old conveyor belts, but was told every time by the defendant that the delivery will be given after disposal of the criminal case. They all the time took the stand once the criminal cases are disposed.
No particular dates given. 1980 से कहानी चल रहा है.
There are dates. There was another round of litigation which had happened between the parties, that also. So their basic stand was, we will deliver the balance material once the criminal cases are over. That in spite of repeated requests and reminders by the plaintiff, the defendant did not give the delivery of the remaining quantity of the contracted material to the plaintiff. However, the defendant started deliveries of old and used conveyor belts to other parties, which was duly brought to the notice of the defendant by the plaintiff in his letter dated 5th June 1982.
This is the breach.
Because breach is subsequent.
This is also breach.
This is also a breach.
Okay, next.
That the police submitted final report number 87/82 dated 6th September 1982 as mistake of facts in Marafadi PS case number 12 within bracket 8/80. The case thus stood closed by the police as none of the allegations were found to be true, as mentioned in the order sheet dated 14th September 1982. One of the criminal cases got closed. One was pending also. That the plaintiff served a legal notice para 19. That the plaintiff served a legal notice dated 16th July 1983 to the defendant, addressed to then managing director and the then general manager materials Bokaro Steel Plant through his advocate, inter alia demanding that either the balance contracted material be supplied or in the alternative a sum of rupees 2,03,822 and rupees 50,000 being security deposit be refunded along with interest latest by 22nd of July 1983. That in spite of service of the aforesaid legal notice, the defendant neither supplied the remaining quantity of the contracted material nor refunded the advance amount at that time. That therefore, the plaintiff was forced to file a money suit number 45 of 83 against the defendant in the court of the subjects to Dhanbad, which was later on transferred to subjects to Bokaro, praying inter alia. 1. That a decree may be passed in favour of the plaintiff against the defendant for a sum of rupees 3,90,322, rupees 2,03,822 on account of advance payment, plus rupees 50,000 on account of security deposit, plus rupees 1,36,500 on account of interest, plus pendente-like interest. Or in the alternative, a decree may be passed in favour of the plaintiff and against the defendant, and directing the defendant to supply the balance quantity of conveyor belts weighing 495 metric ton on taking the balance amount from the plaintiff within a time to be fixed by this learned court, failing which to pay the said sum of rupees 3,90,000 with further interest at 18% per annum. That a decree may be passed for the cost of the suit and interest pendente and future. That any other reliefs to which the plaintiff is found entitled to may also be granted to him. That the defendant in their written statement filed in the said money suit number 45 of 83 categorically admitted about the tender and the contract between the plaintiff and the defendant, and also admitted the quantity of old and used conveyor belts contracted, the advance payments made by the plaintiff, the quantity delivered as well as the balance quantity to be delivered as per the contract. The defendant further admitted in their written statement filed in the said money suit number 45 of 83 that rupees 50,000 was deposited as security deposit against the contract and rupees 2,03,822 as advance payment was lying with the defendant, which were withheld for the reason that the contract had not been cancelled and criminal case was instituted against the plaintiff, and further the defendant defendant in para 11 of the written statement made averment that so long the criminal case is pending, the defendant is not in a position to release the contracted material either under law or under the specific terms of the contract, any sum, much less the sum alleged to be due and payable to the plaintiff. That in the written notes of argument filed in the said money suit number 45 of 83, the defendant has categorically and emphatically said that contract is subsisting and in view of the criminal case, only the delivery of material has been suspended. The categorical submissions made by the defendant in paragraph 13 and 14 of their written notes of argument is quoted below. The defendant made an averment in para 13 as that normally before raising a demand for the refund of security money and or balance of the amount, the plaintiff had the options to take recourse to the provisions of section 75 of the Contract Act. The plaintiff was in law entitled to repudiate the contract if the plaintiff was of the opinion that there is a breach of the contract on the part of sale. The contract in the eyes of law subsists. Only the delivery of the material was suspended. The right to refund the amount in deposit would have accrued had the plaintiff expressed his desire to close the contract and exercise the option available under law, particularly section 75 of the Contract Act. Averment in para 14 is made as contract which has neither been foreclosed nor terminated and which is still subsists in the eye of law. That the learned subject to Bokaro heard the matter, being money suit number 45 of 83 in its entirety, and examined all the oral and documentary evidences presented before him, and after hearing both the parties, the learned subjects to Bokaro passed a judgment and decree on 9th of April 1992, wherein and whereby the defendant was directed to refund the advance amount of rupees 2,03,822 withheld against the supply of used and conveyor belts to the plaintiff along with 12% interest till the date of payment. The security money was not ordered to be refunded with the observation that the contract was still subsisting. This order is at Exhibit 4 minutes. This is a crucial order of the previous round of litigation. That the learned subjects to Bokaro in its judgment referred above has also observed as under. This has been translated from Hindi. This court decides that as because the contract is subsisting and the defendant also accepts this as legally valid and correct, the plaintiff is entitled to get balance 495 metric ton of conveyor belts at the specified rate as mentioned in the contract. But in a money suit, order for supply of balance 495 metric ton conveyor belts by the defendant to the plaintiff cannot be passed. Hence, the plaintiff shall have a willful and competent right, and he will again make request to the company for delivery of the balance material. Even after making of the request to supply the materials, if the defendant does not supply the same, the plaintiff will be within his legal and willful right to recover the same by filing separate civil suit. In view of the findings and examinations stated above, this issue is decided in favor of the plaintiff and against the defendant. Therefore, this court is of the opinion that the plaintiff is entitled to get rupees 2,03,822 plus interest at the rate of 12% per annum from 7th August 1980 till the date of payment from the defendant, except
This is not contradictory. Where do you say that there was a direction to refund the amount? And at the same time, it says that if the defendant does not supply it, then you can go for refund. Is it not contradictory?
No, I'll explain. What had happened was SAIL had taken a plea that the contract is subsisting.
You forget about sale. You just tell me. On the one hand, the court says that the amount is to be refunded.
Only the advance amount,
That's
not
right.
the security deposit.
Fair enough. Only the advance amount
Only the
was to be
advance
refunded,
amount.
right? Because they had failed to supply.
They had failed to supply and they had taken a plea that we will supply after the closure of the criminal case.
That's right.
So the criminal case was pending on that date.
No, they might have taken a stand. But what is the finding of the court? The court is that the defendant was directed to refund the advance amount of such and such till the date of payment with interest, 12% interest also. The security money was ordered not to be refunded with the observation that the contract was still subsisting.
Still subsisting. What had happened is we had given them some advance payment which was lying with them, and we had also given them a security money. So, security money they had withheld it, consciously saying that the contract is not over, therefore we are not liable to refund the security deposit, therefore we are retaining the security deposit. Whereas the supplies have been suspended since the criminal case is pending. Therefore, till the criminal case is pending, we will not be able to make supplies.
Show me that your cause of action to get supplies commenced only upon closure of the criminal case.
Indeed, ma'am. That is what it will come.
Because there is already you took steps, filed a suit, right? You did not wait for the outcome of the criminal case. Nor the defendant waited for the outcome of the criminal case, nor the court waited for the outcome of the criminal case. Right? So you exercised your right, you had a cause of action, and you went to the court. Now, where does the court say that you're fresh, once the criminal case is over, you will have your right to apply for that?
That is what the court says here, that I will have
आप
the
वो
right.
जजमेंट ही पढ़ाइए ना, ये सब आपका प्लीडिंग से क्या चलने वाला है?
That's
जजमेंट पढ़ाइए, एग्जिबिट नंबर कौन सा?
Exhibit 4 है ma'am.
you have a better copy?
My copy is it's not legible.
पढ़िए issues पढ़िए.
Should I start from the beginning?
Page number 7. 7 is the issue.
उभय पक्ष के वादों के आधार पर निम्नलिखित वाद पत्र का सृजन किया गया। क्या वादी को कोई उचित वाद हेतुक है? क्या वादी का वाद स्वीकार्य योग्य है? क्या वादी का वाद काल बाधित है? क्या वादी का वाद आवश्यक एवं अनावश्यक पक्षकार के कारण खराब है? क्या वादी प्रतिवादी से दावा किए गए रकम पाने के अधिकारी है? क्या वादी प्रतिवादी से संविदा के शर्तों के अनुसार शेष बचे कन्वेयर बेल्ट्स मेट्रिक टन उचित मूल्य लेकर आपूर्ति पाने के अधिकारी हैं? क्या वादी कोई अन्य अनुतोष प्रतिवादी से पाने के अधिकारी हैं? वाद पद संख्या 700। यह दोनों वाद पद इस वाद की मुख्य रूप से विचारणीय वाद पद के समर्थन में वादी साक्षी संख्या 1 वीरेंद्र नाथ महतो, शिव शंकर लोधा, नरेश प्रसाद लोधा, प्रेम कुमार को साक्ष्य हेतु समाहूत किए हैं। वादी द्वारा समाहूत 4 साक्षियों में वादी साक्षी संख्या 1 एवं 3 मुख्य रूप से औपचारिक साक्षी हैं तथा वादी साक्षी संख्या 5 एवं वादी हैं तथा वादी साक्षी संख्या 2 वादी के संबंधी हैं तथा वादी के फर्म में वे मैनेजर के हैसियत से काम करते हैं तथा मुकदमे का देखरेख करते हैं। इसके अलावा वादी ने अपने वाद के समर्थन में प्रदर्श 1 माराफाड़ी थाना केस संख्या के आदेश का अभिप्रमाणित प्रतिलिपि दिनांक 16 के पत्र एवं टेंडर का छाया प्रति, क्रम विबंध पत्र का छाया प्रति, अधिवक्ता
नहीं पढ़ा है आपका फाइंडिंग पढ़िए, इतना नहीं पढ़ना। Just show me the relevant portion you want. Do you have a copy of this, Judge?
Because I have quoted at page 13 of my memo of appeal, the exact Hindi, the exact verbatim. Para page
13.
Page 13 of my memo of appeal, I have quoted.
Finding है.
Well, this is the submission of the sale where they say that after disposal of the criminal
We are
case they
looking
will
for
deliver.
finding. Submission से नहीं होगा. Submission they all have no value. Show me the finding. There was no restraint order in so far as release of goods are concerned.
There was no restraint.
There was no restraint
Express-
by any competent court.
No comment. It was sale. It has taken a stand that we can release only once the
They will
criminal-
take many stands. Was this property seized by CBI?
No.
There is no seizure.
No, sir.
There is no restraint order.
There is no restraint.
Only a criminal case.
Only a criminal case. They were relying on some contractual terms we said that it cannot be supplied because some criminal case is pending. That is what stand sale to. Therefore, the learned court said that we have the right to invoke the supply of balance quantity after the disposal of the criminal case.
वही दिखाइए that your right to claim balance quantity will accrue after the disposal of it. ऐसा finding दिखाइए.
We have page, internal page 16 of the judgment.
Of
Exhibit
the
4
Hindi
of the Hindi.
16.
I have a copy which is readable. So should I know?
ठीक है आप पढ़िए ना. आप क्या पढ़िएगा?
Page 16.
हाँ.
Bottom स्वीकारात्मक तथ्य है कि वादी का प्रतिवादी के यहाँ अग्रिम के रूप में अभी भी मूल्य ₹100 जमा है तथा सिक्योरिटी के रूप में मूल्य ₹50,000 भी वादी का प्रतिवादी कंपनी में जमा है। यह भी स्वीकारात्मक तथ्य है कि संविदा के अनुसार प्रतिवादी कंपनी को शेष सामान अर्थात 750 मीट्रिक टन कन्वेयर बेल्ट्स वादी की आपूर्ति करना था। अर्थात विधि अनुसार यह सामान जिसे प्रतिवादी कंपनी ने वादी को नहीं दिए उसे पानी के वादी अधिकारी हैं। सो माय राइट इज नोटेड। जैसा कि पूर्व में विनिश्चय कर चुका हूं कि प्रतिवादी ने अपने प्रतिवाद पत्र एवं अपने बहस के मध्याह्न सिर्फ एक ही मुख्य बिंदु पर अपना प्रतिरक्षा रखते हुए दावा किए कि चूंकि उपरोक्त वर्णित फौजदारी मुकदमा अभी लंबित है इसीलिए प्रतिवादी वादी को संविदा के तहत कन्वेयर बेल्ट्स देने में सक्षम नहीं है। लेकिन उपयुक्त विनिश्चयों के से स्पष्ट हो जाता है कि इस वाद में वर्णित मुख्य मामला फौजदारी माराफाड़ी थाना केस संख्या 100 में अंतिम प्रतिवेदन तथ्य के मूल करके समर्पित कर दिया गया है।
फाइनल फॉर्म जमा हो गया।
हाँ, एक केस में, 2 केसेस थे, एक केस में फाइनल फॉर्म तथा वादी एवं प्रतिवादी कंपनी के सभी कर्मचारियों को इससे उन्मुक्त किया जा चुका है तथा ये भी मुख्य एवं आधारभूत फौजदारी मुकदमा था जो मिथ्य पाए गए और उसके बाद वादी ने सामानों की आपूर्ति के लिए व्यक्तिगत रूप से संपर्क भी स्थापित किया तथा वकालतन नोटिस प्रदर्श संख्या 5 भी प्रतिवादी कंपनी को भेजा। लेकिन प्रतिवादी कंपनी ने ना तो बचे सामानों की आपूर्ति किया और ना रुपया ही अदा किया। प्रतिवादी ने अपने प्रतिवाद पत्र एवं अपने बहस के मध्याह्न स्पष्ट रूप से दावा किया है कि उभय पक्ष के बीच संविदा अभी अस्तित्व में है। सो इट इज वैलिड। दे से दैट द कॉन्ट्रैक्ट इज स्टिल वैलिड। तभी तो ये न्यायालय ये विनिश्चित कर चुकी है चूंकि संविदा अस्तित्व में है इसीलिए वादी प्रतिवादी से सिक्योरिटी मनी का मूल्य ₹50,000 पाने के अधिकारी नहीं। There is a clear finding that since the contract is valid, I am not entitled to refund of the security deposit. तब तो यह भी सत्य है कि विधि अनुसार वादी प्रतिवादी से संविदा में वर्णित शेष कन्वेयर बेल्ट्स वर्णित मूल्य पर पाने के अधिकारी है। उभय पक्ष के वादों में यह भी स्वीकारात्मक तथ्य सामने आता है कि किसी भी न्यायालय द्वारा प्रतिवादी कंपनी को वादी को सामानों को आपूर्ति करने से निर्देश नहीं किया गया है, मतलब देयर वाज नो रिस्ट्रिक्शन एज पर एनी कोर्ट ऑर्डर। फिर इस बात पर आश्चर्य होता है कि प्रतिवादी कंपनी ने क्यों नहीं संविदा में वर्णित सामानों की आपूर्ति वादी को किया। अतः ये न्यायालय ये अभी निर्धारित करती है कि चूंकि संविदा अभी अस्तित्व में है और प्रतिवादी भी इसे वैध एवं सत्य मानती है, इसीलिए वादी संविदा में वर्णित शेष कन्वेयर बेल्ट्स सो एंड सो मेट्रिक टन संबंधित मूल्य पर वर्णित शर्त पर पाने के अधिकारी हैं। लेकिन वर्तमान मुद्रा बाद में शेष सामान को पाने के लिए अनुतोष की आकांक्षा वादी ने किया है, लेकिन वर्तमान मुद्दा बाद में संविधा में वर्णित शेष कन्वेयर बेल्ट सो एंड सो मेट्रिक टन प्रतिवादी द्वारा वादी को आपूर्ति करने का आदेश नहीं दिया जा सकता। इसीलिए वादी को यह ऐच्छिक एवं सक्षम अधिकार होगा।
नहीं, ये फिर से पढ़िए, ये वाला। लेकिन
वर्तमान मुद्रा
वर्तमान मुद्दा है।
नहीं, it's मुद्रा, money suit.
मुद्रा मतलब
अच्छा अच्छा, मुद्रा वाला
Money
मनी सूट, चलिए।
लेकिन
वर्तमान मनी सूट,
मतलब लेकिन वर्तमान मुद्रा वाद मतलब इट शुड हैव बीन बाद लिखा हुआ है, इट शुड हैव बीन बाद।
हाँ,
मुद्रा वाद में शेष सामान को पाने के लिए अनुतोष की आकांक्षा वादी ने किया है, लेकिन वर्तमान मुद्रावाद में संविदा में वर्णित शेष कन्वेयर बेल्ट सो एंड सो प्रतिवादी द्वारा वादी को आपूर्ति करने का आदेश नहीं दिया जा सकता है। इसी
ये लगता है कि आपने ऐसा प्रेयर नहीं किया।
और उस प्रेयर तो है, आई हैव कोटेड द प्रेयर मतलब
ये सूट में, मनी सूट में,
मतलब देयर वाज अ प्रेयर,
मनी सूट में डायरेक्ट टू
मतलब
रिलीज द
so that has been quoted in my plaint also, all the prayers मतलब at page at para 19 para 20 of the plaint, internal page 6, para 21, last part of the prayer means, and directing the defendant to supply the balance quantity of conveyor belts weighing 495 metric ton on taking the balance amount from the plaintiff within a time to be fixed by this learned court, failing which to pay the said sum of rupees 3,90,000 with further interest.
So you made an alternative plea that either you
Supply or
refund the money or you supply, right? So the court accepted your part alternative. That is, court asked for
A
refund
part
of
of it.
rupees.
only the advance money was refunded.
Advance money was refunded.
Security deposit was not
Security
refunded.
deposit was not refunded.
Since they took the ground that contract is valid and subsisting, and we are waiting for the outcome of the criminal case.
अच्छा, अब ये जरा इसको पढ़िए। वादी ने किया है शेष सामान को पाने के लिए अनुतोष की आकांक्षा वादी
किया है, लेकिन वर्तमान मुद्रावाद में संविदा में वर्णित शेष कन्वेयर बेल्ट मतलब दैट इज द बैलेंस क्वांटिटी प्रतिवादी द्वारा वादी को आपूर्ति करने का आदेश नहीं दिया जा सकता। इसलिए वादी को ये ऐच्छिक एवं सक्षम अधिकार होगा कि वे इन सामानों को आपूर्ति के लिए प्रतिवादी कंपनी से पुनः प्रार्थना करें। अगर प्रार्थना के बाद भी उन सामानों को संबंधित मूल्य पर आपूर्ति नहीं करते हैं तो उन्हें वैधिक एवं ऐच्छिक अधिकार होगा कि वे अलग से दीवानी वाद प्रतिवादी पर दायर कर उपरोक्त सामानों को वसूल कर सकता है। अतः उपरोक्त विनिश्चयों एवं विचारण के आधार पर यह वाद वादी के पक्ष में एवं प्रतिवादी के विरुद्ध विस्तृत की जाती है तथा यह न्यायालय इस अभिमत का है कि वादी प्रतिवादी से दावा किए गए सिक्योरिटी मनी मूल्य 50,000 रुपए को छोड़कर शेष राशि मूल्य 700 अलॉन्ग विद इंटरेस्ट 12% सालाना सूद के हिसाब से दिनांक 700 से रकम की वसूली तक पाने के अधिकारी हैं। लेकिन इनको जो अतिरिक्त अनुतोष शेष कन्वेयर बेल्ट्स का डिग्री पाने का प्रश्न है, उसके लिए वादी अलग से वाद ला सकते हैं अगर इनकी प्रार्थना पर प्रतिवादी कंपनी वर्णित सामानों को आपूर्ति नहीं करती है।
कहाँ लिखा है क्रिमिनल केस खत्म हो जाएगा तब तक?
That is their submission. That is been
Submission is not the finding.
based on this submission, madam, this is the finding. Based on this submission, this is the finding.
कहाँ लिखा है कि क्रिमिनल केस खत्म हो जाने पर ही नहीं होगा?
Madam, that is their submission, madam. That internal page 7.
That may be submission, but that is not the finding of the court.
The court says that the contract is valid. Contract subsists, and I have the right to claim the materials. So, madam, what happened subsequent to this judgment? I issue them a letter requesting that please supply. Thereafter, madam, they take this plea that since they take the same plea that since the criminal case is pending, we cannot supply.
They responded to that letter.
Madam, they did not respond to that letter.
Then
Madam, we had recorded that we had met the officials, and this is what we have stated. They never objected to that letter. Exhibit 10, madam.
no. What is your pleading further?
Exhibit 10, if I may place, madam.
No, not from the exhibit. You
I'll
place
place
it
the
from the
pleading.
plate. Yes.
Madam, at para 25, madam. 24 was the order, madam, which we had quoted. 25, para 25. That in acceptance and pursuant and compliance with the judgment and order dated 9th April 1992 of the learned subject to Bukaro in money suit number.
ये पैरा नंबर 22 क्या है? Written notes of argument.
Madam, inka written notes of argument.
That is not an exhibited document.
What is it?
It's not an exhibited document.
Written notes of argument has got no value in the eyes of law. It does not form a part of the pleading, nor does it form a part of the record.
And it is not even exhibited before trial court. It is not even marked.
Exhibit नहीं कर सकते ना written
ना ही
note of
X mark
argument.
हुआ है, ना ही X mark हुआ है. So it's
Written note of argument कहीं
नहीं
mark
हो
होता है क्या?
यही मेरा कहना है. It's not a part of pleading.
It is neither a part of pleading nor it is a part of evidence.
Their submissions are recorded in the order. So written notes of argument, madam, that way is being dealt with their submissions in the order itself.
गलत है
at
ना?
page 7.
नहीं consider कर सकते written notes of argument.
इनका submissions, जो इनका submissions है, that along with their written statement, that has been quoted in the order itself at internal page 7.
उनका written statement कहाँ?
इस केस में तो मतलब they have not filed any written statement. They have chose not to file. In the other case, मतलब para page 7, internal page 7 records their submission.
That is also not an exhibited document. That is X6 mark for identification.
No, order is a public
That the
document. Exhibit 4. I am talking about Exhibit 4.
Exhibit 4 में दूसरे उसी केस का written notes of argument quoted. That is why there is no finding of the trial court at the first money suit as to when will you apply. There is no finding. The court says that you will apply, and if you have a fresh cause of action, you will get it.
Indeed, madam. Para page 7 में madam, what were their submissions is recorded.
Does the court record any finding that they were justified in not supplying? Is there any
That
finding
one
that
will have to
that they were
check.
justified in not supplying? ये जो refund का order किया है आपको, is there has to be a background to this?
Court accepted their stand that the contract is still
क्या आपको
valid and
लग रहा है
subsisting.
court accepted the stand?
Accepted
आप
this
show it
stand.
from the order that the court accepted the stand that it cannot be supplied. कभी ऐसा होता है पढ़ने में ना, ऐसा हो जाता है, इसीलिए आप हमको फाइंडिंग से दिखाई. जब तक हम उसको ब्लैक एंड व्हाइट में नहीं देखेंगे, I will not accept it as it is. Your submission cannot be accepted because the court in its finding does not record that you will be entitled to apply after the criminal cases are over.
No, it doesn't say, the court doesn't say in the finding that I will be entitled to apply after the criminal case. It says, but I am entitled to apply afterwards, after the judgment.
Yes.
So I'll place the events which had happened subsequent to the judgment.
Okay.
Para 25 of my plea. That in acceptance and pursuant and compliance with the judgment in order dated 9th April 1992 of the learned subject to Bukaro in money suit number 45 of 83, the defendant refunded the amount of rupees 2,03,000 along with interest to the plaintiff in the same year, while the security deposit of rupees 50,000 was retained by the defendant till date and still lying with the defendant. No appeal has been preferred by the defendant against the said judgment in order. That the other criminal case bearing Marafadi PS case number 15 of 11 of 80, in which there was an allegation of malpractice in the process of awarding the contract, has also ended in acquittal of the plaintiff as well as all the other accused from criminal charges by judgment dated 13/3/2015, passed by the learned special judge Vigilance Dhanbad. That certified Xerox copy of the said judgment dated 13/3/2015 had been sent by the plaintiff to the Chief Executive Officer of the defendant company by registered post on 9/9/2015, which has been duly received by him. That the plaintiff, by his letter dated 20/9/2015 sent through registered post, has made a request to the Chief Executive Officer of the defendant company for resumption of delivery, lifting of balance contracted quantity of 495 metric ton of used and old conveyor belts at the contracted rate of rupees 6650 per metric ton plus applicable taxes as per the directions and observations of the learned subject to Bukaro, made in his judgment and order dated 9th April 1992, which has been duly received by him. That further in the said request letter, the plaintiff has expressed his willingness and readiness to deposit the payments of the subsequent installments as soon as communication is received from the defendant. That as per the procedure and practice, the advance installment payment towards value of the material can only be deposited with the accounts department of the defendant company after receiving written communication by the plaintiff from the defendant company, as is evident from past such communications letter dated 22nd April 1980. That it is submitted that the plaintiff has not received any communication whatsoever till date from the defendant regarding resumption of the delivery of the balance quantity of 495 metric ton of old and used conveyor belts as per terms of the contract. That it is further submitted that there is a regular arising of old and used conveyor belts in Bokaro Steel Plant in the operation of the factory, as conveyor belts are discarded and replaced from time to time in various shops of the plant after their use. That it is further submitted that it is regular practice of the defendant company to sell the contracted material, used and old conveyor belts since inception of its production process to various parties through auction, tender, e-auction, etc. That it is submitted that as per the list of materials attached to the tender, lot number 22, serial number 33, used and old conveyor belts of assorted sizes, quantity 714 metric ton, was to be lifted from NP Stores construction yard of the plant. However, later on the plaintiff was directed by the officers of the defendant company to lift the material from other locations, also inside the plant premises, and deliveries were accordingly given from other shops locations as well. It is submitted that since conveyor belts are discarded and replaced from time to time in different shops of the plant after their use, and therefore there is availability of used and conveyor belts with the defendant company, the plaintiff is entitled to lift the balance materials at the contracted rate as per the contract, which is still subsisting, as well as the commitment and averments made by the defendants in money suit number 45 of 83 referred above. Dispatch notes issued for material lifting from different locations is more fully described in Schedule C of the plaintiff. That it is submitted that the said judgment and order dated 9th April 1992 of the learned subject to Bukaro was accepted by the defendant and duly complied at the first instance, and therefore the same is binding upon him, and the defendant is under statutory obligation to fully comply the same as mentioned in para 23, 24, 25 above. That it is submitted that the defendant company is having full knowledge and understanding that it would be obligatory and binding upon them to effect the delivery of the balance contractual quantity at the contracted rate after disposal of the criminal cases in fulfillment of their promise and averments made in the money suit. That the contract is subsisting and only the delivery of the material was suspended in view of the criminal cases. That the plaintiff has suffered huge losses due to non-delivery of the contracted quantity. That the cause of action arose on 26 September 1979 when the plaintiff submitted tender for lifting of used and old conveyor belts of assorted sizes at rupees 3,500 per metric ton. Further, on 28th, 29th of January 1980, when negotiation committee meeting was taken place, and the rate was revised to rupees 6650 per metric ton to lift the materials on installments. On different dates when the material was lifted by the plaintiff by making payment of material. It also arose on 6/8/1980 when Marafadi PS case number 12 of 80 dated 7/8/1980 was instituted under section 379, 411, 120 of IPC against the accused person. It further arose on 7/8/1980 when the supply of the contracted material was stopped, and it also arose on 11/11/1980 when another Marafadi case number 1511 of 1980 was instituted under section 406, 409, 120B of IPC and under section 51A and 52D of the Prevention of Corruption Act against the officials of the defendant company. It further arose on 5/6/1982 when the plaintiff requested the defendant company for supply of balance material. On 16/7/1983, the learned advocate of the plaintiff requested the defendant for refund of money and supply of balance material. It also arose on 9/4/1992 when the learned court of subject 2 was pleased to pass judgment and degree in money suit number 45 of 1983 filed by the plaintiff against the defendant company, and in the said money suit, Bokaro Steel Plant submitted that due to pendency of criminal case number 1511 of 80, no refund of advance amount would be made to the plaintiff nor any material could be supplied to the plaintiff. It also arose on 13/3/2015 when special case number 8/1989 ends up in acquittal of the plaintiff and others by the judgment and order passed by the Special Judge Vigilance Court Dhanbad. It also arose on 9/9/2015 when the plaintiff set a copy of the judgment dated 13/3/15 of special case number so passed by Special Judge Dhanbad to CEO of BSL by registered post, and further on 18/9/2015 when the plaintiff made request to the CEO for resumption of delivery of the balance contracted quantity of 495 metric ton of used and old conveyor belts as contract is still subsisting. That this learned court has jurisdiction to try the suit, and for the purpose of the court fee, the suit is valued at ₹33 lakhs and ad valorem court fee is pending paid thereon. There were certain paragraphs which were allowed by law of amendment. Paragraph 34A, that without prejudice to the above and also to the prayer
You
of the
claim damages on account of non-supply because the market value of the property has increased substantially. So market value, their market value has not increased, that is stagnant. You saw का market value चला.
Because the contract was subsisting.
That's
they had only suspended the deliveries. So we were asking that you now deliver the material, and because of non-delivery,
see, in the earlier suit, there was no indication in the finding that you will have the right to seek supply after disposal of the deliveries. That might have been taken. A plea might have been taken. Numerous pleas are taken. Non-joinder pleas also taken. Right? So that right is that you will apply after the disposal of the criminal case. From where do you get this?
Well, if we kindly have exhibit 10.
Exhibit 10. And the fact also remains that it is not a case that during the pendency of the case, criminal case, they did not give you any supply.
They did not.
They did not give you
They
any
did not.
supply?
They had suspended the supply immediately the criminal case was instituted. In fact, they had taken advance money from us for supplying 250 metric ton. So they could have supplied us 250 metric ton, but they stopped at 219 metric ton immediately because the case was filed.
Exhibit 10 is marked X. So marked X. Exhibit 10 is what document?
This is the original letter which we had written to them, after the disposal of the earlier round of litigation.
What is the date of the letter?
10th February 1993. Because Exhibit 10 is not marked X, Manoj, it is without objection.
I'll just find it. 10/2/93.
10. May I place this now? By registered post to the managing director, sale Bokaro Steel Plant, Bokaro Steel City. Subject: delivery of balance material 495 metric ton old and used conveyor belts. Reference: letter number so and so dated 20th February 1980 from controller of stores. Dear sir, the following facts are being brought before you once again for taking the required necessary action in respect of the tender number so and so for sale of used and old rejected salvaged conveyor belts. That as per the directions of the court, the payments have been made to us by your company in compliance with the order and judgment dated 9th April 1992 passed by subjects to Bokaro in money suit number so and as because the contract is subsisting, the security deposit of ₹50,000 against the contract has been retained by your company. That for taking delivery of the balance quantity of 495 metric ton of used and old conveyor belts, your officials are saying that the supply of balance quantity of materials cannot be effected while the criminal case being Marafadi PS case number 1511 80 is pending and the delivery will be made as per the outcome of the case. We have been advised by your officials to wait till the disposal of the case for lifting of the balance material of contract as per procedure. That we are ready and willing to deposit the material value installment as soon as communication is received from your end in this regard as per the procedures and terms and conditions of the contract. It is therefore submitted that while we are waiting till the outcome of the criminal case, you and your company are stopped from taking any adverse actions in the matter. Because this was never objected to and they never terminated the contract till the disposal of the criminal case. They retained our security deposit, contract was valid, and once the criminal case, the other criminal case was disposed, we again given them a letter in writing that we are ready with the payment, please supply us the material since now that case is over. But
when was the case over?
In 2015, in 2015. And immediately thereafter we communicated the copy of the order first. That case, the criminal case, was over in 2015. We communicated the copy of the order first to them. That para 26 of my claim. Date of the case was disposed on 13th March 2015. And we submitted the copy of that judgment with the Chief Executive Officer of the defendants. Thereafter, since there was no action, then we wrote them a letter that you please supply since that case is now disposed. And there was no objection to our letter and they did not supply. So they have never terminated the contract. Contract remained valid all the time. They had retained our security deposit all the time on the ground that contract is subsisting. Now the moment what they say, the officials of the defendant, that we are waiting for the outcome of the criminal case, the moment criminal case is decided, we approach them again.
So, arising out of the same contract, there were deferred supplies.
They were deferred supplies. Contract was never terminated. If contract would have been terminated, they would have written a letter to us and they would have refunded the security deposit. But they consciously retained the security deposit for all this time.
This is on limitation.
Then
you wanted supplies. What was the relief rate for?
Because I had prayed for two release. First is for specific performance, that is supply, and in the alternative means we have prayed for damages. Our prayer for damages, which were made, have not been considered at all. In fact, the learned court only considers our prayer for specific performance. I will demonstrate from the judgment itself.
So we will consider, no?
Indeed.
We will consider.
Indeed. I am just saying that those were not considered at all. In fact, no issues were framed on my prayers. The only issue which was framed was with respect to limitation. And Article
So
54.
now your commercial sense is that you give me the material at the same rate.
At the same rate, because contract was subsisting. They would have taken a stand, they could have refunded my security deposit and terminated my contract. They never did that.
And there was a finding also that contract is not terminated.
It is money. Contract is still subsisting and valid, that is the finding. And this finding was never challenged by them, that contract is not subsisting and not valid. And on the ground of limitation, the learned court invokes Article 55. Where is articles?
What was the process of making the supplies?
Because they would intimate us whatever the quantity is available with them. They will ask us for money. Like when in the earlier round, they asked us for the money of 250 metric tons. Once they will ask us the money, then on that basis we will remit the money and then deliveries will be made.
And what is the evidence on damages? Because now you have an alternative relief. What is the evidence on damages?
We had filed several documents, documentary evidence of there, whereby we showed that we had corresponding contracts with other parties, because we are traders basically. So we had contract with other parties to supply this material. Because you breached, there was a consequential breach by us, and since the material now was available at a much higher price.
There was a breach from your end also.
Because they failed.
What was the consequence of that breach?
Well, I'll read the pleadings and the evidence.
No, I just want to know, we will read the pleadings and evidence. I just want to know what was the consequence of that breach. Because there was back-to-back contract.
They were back to back.
They breached. So you also breached.
I also.
It became impossible for them to supply. Because of pendency of the criminal case.
That is there.
So there was a frustration for some time. There was a frustration for some time.
Frustration for some time. Suspension.
For some time. So when they breached, you defaulted. So what happened to your contracts?
Well, that is what has been pleaded. I'm not fully prepared on damages. I was prepared on specific performance. I'll read the pleadings. It is very clear in the pleadings and the evidence. The pleadings which were permitted by way of amendment are handwritten notes. Along with my memo of appeal, I have given the typed copies. So it will be convenient for members.
And one thing you keep in mind, because you have made an allegation that they were diverting your material. There is a clear allegation of diverting.
They were selling it to other parties.
So they were selling it to other parties.
Not supplying.
It means that they were already in breach.
They were already in breach. They were supplying to other parties. Their only ground was that we can supply to other parties because in your case the deliveries are suspended because of the criminal case pending.
There may be multiple contracts.
Various parties, they might have.
they have a pool of scrap material.
These
Out of that, it is not something which is earmarked for you, kept for you.
no, it is not.
They have pool of material, and then since there was a criminal case against in connection with you, so they continue to supply to somebody else.
But
Since there was no seizure,
no season. No season. No season.
so these goods might not have survived by the time the second suit was filed.
No, these goods are continuously being generated. These are basically scraps, which keeps on generating on an everyday basis. So they do not have a shortage of the material. They always have the please
नहीं,
that
उनका कमर्शियल सेल से 1980 का रेट में नहीं देना चाहता.
दे देना चाहिए तो उसी समय मतलब इतना दिन प्रोलॉन्ग किए मेरा सिक्योरिटी मनी रोक के रखे इतने साल. They retained it consciously. They could have terminated the contract when the criminal case was filed. At that moment they could have terminated. But they took a
ये लोग तो सेल है ना, हम मीडिएशन में भी नहीं ले सकते. वो
public
लोग
sector
कुछ होगा नहीं, पब्लिक सेक्टर में मीडिएशन का कोई स्कोप नहीं है. They will never take a decision. So whatever it is, we have to listen.
I have filed a typed copy. The amendments are handwritten. So at page 40 minutes of my memo file, the typed copy is there. Page 40.
Memo copy का pic copy नहीं दिखेगा. Handwritten नहीं, typed तो नहीं.
Typed copy was subsequently filed once.
अच्छा पढ़ लेंगे, handwritten भी पढ़ लेंगे. पढ़ लीजिए. I'll read it from the loan copy. Your amendment petition must be on record. We can read it from the amendment petition also. तो पढ़िए आप amendment. 34A.
34 images. That without prejudice to the above and also to the prayer of the plaintiff with respect to specific performance of the contract for delivery to the plaintiff of 495 metric ton of the consumed materials being the used and old conveyor belts at the contracted rate of rupees 6650 per metric ton plus sales tax, the plaintiff humbly submits that if the defendants have performed its contracted obligation of delivering the 495 metric ton of the concerned materials, which is old and used conveyor belts, at the contract price of rupees 6650 per metric ton plus sales tax, then the plaintiff would have sold the said material in the market to third parties, and the plaintiff would have made profit, being the amount of market price of such material reduced by the purchase price of such material reduced by the purchase price of the plaintiff from the defendant. However, as the defendants have failed to deliver the said materials to the plaintiff has suffered the direct loss of said profit, which the plaintiff shall have made by selling the said materials to third parties. That it is humbly submitted that the plaintiff had requested the defendant by its letter dated 18/9/2015 to deliver 495 metric ton of the concerned materials, being the used and old conveyor belts, as at the contracted rate of rupees 6650 per metric ton plus sales tax. However, the defendants did not deliver the said materials to the plaintiff. The rate at which the plaintiff could have sold the said materials to third parties during September 2015 and to early 2016 is rupees 35,000 per metric ton. Accordingly, the plaintiff would have made a profit of rupees 35,000 minus rupees 6650 per metric ton, which comes to rupees 28,350 per metric ton. The total profit which the plaintiff would have earned is rupees 28,350 metric ton multiplied by 495.45 metric ton, which comes to rupees 1 crore 40 lakhs 46,007. Thus, the plaintiff has suffered a clear loss of earning or profit of rupees 1 crore 40 lakhs 46,007 rupees because of the non-performance of the contractual obligation of the defendants to supply 495 metric ton of the concerned materials, being the used and old conveyor belts at the contracted rate of rupees 6650 per metric ton plus sales tax. The plaintiff is entitled to be compensated by the defendants for the said loss of rupees 1 crore 40 lakhs 46,007 rupees. That in addition to the above, it is humbly submitted that the plaintiff was waiting for almost 36 years since 6/8/1980 to take delivery of 495 metric ton of the concerned materials, being the used and old conveyor belts from the defendants. The plaintiff, because of the non-delivery by the defendants, could not sell the said materials to the buyers or customers of the plaintiff. The plaintiff, because of this non-delivery to his customers, suffered loss of reputation, goodwill and mental harassment. The said long wasted period of 36 years has caused huge losses to the plaintiff. The plaintiff has wasted valuable period of 36 years only because of the non-performance of the contractual obligation by the respondents. The plaintiff is entitled to compensation of rupees 20 lakhs for the loss of reputation, goodwill and mental harassment.
When he, in order to claim damages, and if you say that you had suffered losses because of that, firstly you have to show that there are existing contracts. Secondly, you have to show that you did not supply them, or you procured it from the market and supplied it. And from the market you had purchased it at the rate of, maybe if it was contract price was 100, you purchased it for 110 and you supplied it for maybe 120. So this 10 was your profit, but you paid extra 10 rupees for the purposes of purchasing it from the market. There is no such pleading to that effect.
Our pleading is, there are twofold pleadings. First pleading is that because you did not supply to us, at that time the market value of the goods had increased. Market value of the goods at that time was 35,000.
Absolutely vague. Absolutely vague. You have given the rate of only one period, that is of 2015.
2015.
Yes.
Because
So if you had suffered, losses,
that is the time of breach.
you are a trader,
I'm a trader.
right? So you will purchase it and sell it. So you
So I would have purchased at 6650 and could have sold at 35,000. That is what I say. I could have sold it, and that market price, I have proved that market price at that time was 35,000. And breach, I have to show it at the time of breach. Well, breach has happened in 2015.
So breach had happened earlier only.
But that breach was continued. They said that now we will supply to you after the disposal of the criminal case. So we were waiting for the disposal of the criminal case, and then that happened in 2015. And then we requested them to supply, and they did not supply. So at that is the moment, Manoj, where breach has finally happened. Because then there was nothing pending. Their ground to suspend was over. Their ground not to deliver was over. So now they had no justified ground to retain the deliveries. So in 2015, Manoj, I am saying that I could have sold these goods at market price, which was 35,000, and I could have made a profit.
Had you received the goods in 1980?
I received only part.
Just have you received the goods in 1980? Would you have retained till 2015?
I would have not retained.
Not retained.
I would have sold them.
So at best, what damages can you claim? That these goods, I'm a trader. It was available at rupees 100 per metric ton in the year 1980. You did not supply it, and since the market value of that goods were 110, so I suffered a loss of rupees 10 per metric ton. Right? But you are seeking supplies at the old rate, and then you are asking them that since that particular goods which you would have bought in the year 1980, right, at the same rate it is to be given now, and now you will sell it for. This is not the way in which the damages is calculated. You see, for the purpose of damages, you are also supposed to take steps to minimize the damages, right? If the goods were available at that point of time at rupees 100 and you were in need of goods, then you would have taken it from the market and sued them for it. But that you never did.
Damages are consequential to breach. Final breach has happened in 2015. But contract was valid till 2015. This is undisputed. So in 2015, they were obligated under the contractual terms to supply me at 6,650 per metric ton. So if they would have complied with the contract, they would have supplied me at 6,650 minutes, and I could have sold it at 35,000, which was the market price then. And because of that breach in 2015, Manoj, I have suffered this consequential loss. If they would have supplied me in 1980, Manoj, the contract would have, there was no question of damages. Because they retained my security deposit for all this time. They continuously said that the contract is subsisting. They prolonged the delivery, and now when the contract is subsisting, they were required to supply me in 2015. It is then where they breach, where they say they don't supply me. So if they would have supplied, if the contract would have been specifically enforced, they would have supplied, I would have bought at 6,650 rupees in 2015 also. They have never taken the plea.
We'll continue here.
If they would have taken the plea, no, we could not have supplied because the prices had gone up. This was not the plea by them.
They have not contested the suit.
They have not contested.
The court has applied which article?
55 has been applied.
Limitation Act. They have applied 55.
54 ought to have been applied. While my prayer for damages was not considered, but
this is over and above the fact that you want to apply 54.
54. Even if 55 is applied, 55 has to be applied in the right sense of the facts. Court considers only my prayer of specific performance. It does not consider my prayer of damages. It ignores my prayers, but it invokes the provision under the Limitation Act, which is applicable for breach of contract for damages.
We need to rise today. आज का जितना बचा है ना हम लोगों का वो जो ओल्ड वाले केसेस हैं जितना है वो सब सप्लीमेंट्री बनाइए सारे केसेस सारे डालिए क्योंकि सबको नोटिस होना चाहिए कि उनका केस लग रहा है. लिख के फाइनल डिस्पोजल में डालें, एक में भी दो। अगर हम अगर ये पुराना केस में से अगर एक केस भी लॉन्च कर दिए तो आई थिंक दैट इट्स एलिजिबल। In one case, it's an achievement, I suppose. Arguments has remained inconclusive. लिख दीजिएगा as the time is over. Continue. Second half. First appeals we are going to take up only in second half. Okay, Jesse.